Hi, everyone. My name is Adam Cohen. I'm an immigration attorney with Siskind Susser in Memphis, Tennessee. And every now and again, I'm going to want to try to give you all some updates in the areas of law where I practice, which are primarily academic and healthcare immigration. So let's share a little bit of news, shall we, that has arisen over the last week and a half or so. And the first one that we have to talk about for sure is the survival of DACA, at least for now. And you may wonder, well, why is DACA within this domain of academic and healthcare immigration? And actually, the reason is pretty simple. So there are many, many students that are on DACA status, and there's also many DACA medical students even, and DACA professionals, DACA healthcare professionals as well. So we're going to talk about that first. The other thing is that this is a case that is, it's DHS versus the Regents of the University of California. So again, it's another example of the universities leading the charge in fighting back against the Trump administration on some pivotal areas, such as it was also the travel ban and unlawful presence litigation. So DACA survives for now. And if anyone remembers, everyone remembers, the DACA program began in 2012, and it was a way for there to be sort of a forbearance, deferral of removal for DACA, for young people who came to the U.S. Were very, very young. They don't even remember coming to the U.S. in most cases. They were so young. And this was sort of a way to protect these kids. And it also gave them work authorization, in certain cases, the ability to travel as well. And it's always been, it was controversial from the very beginning. And in September of 2017, former Attorney General Jeff Sessions, with a gleam in his eye and a very giddy disposition, ended the program that made it very, very difficult then for many of these DACA recipients who were left again in a very difficult period of limbo. So since that rescission, a lot has happened in terms of litigation, and it comes to the U.S. Supreme Court once again for them to make a decision, which occurred yesterday. And basically, it was an opinion that was issued directly from Chief Justice John Roberts. And Justice Roberts found basically there were two findings to this Supreme Court decision. The first one is that the Department of Homeland Security's decision to rescind DACA is reviewable under the Administrative Procedures Act, which is really very, very important because the Administrative Procedures Act basically governs how federal agencies make their law, and it subjects them in most cases to review by the federal courts, so review by a separate branch of the government, really just pointing out that separation of powers and checks and balances system that we have in U.S. government. So that was first an excellent finding. I think the government was trying to argue that, that this is not reviewable by federal courts because it's just a law enforcement action. That's all that deferred action is, that DACA is. And so basically saying that this is agency discretion. But the government found that it's not quite that. DACA is much, much more than simply a law enforcement program. And it accorded certain benefits to DACA recipients, such as work authorization, in certain cases, eligibility for Social Security and Medicare as well. So became reviewable, and therefore the second point of the decision was that the Department of Homeland Security's decision to rescind DACA was arbitrary and capricious under the Administrative Procedures Act. And basically what they're highlighting here is that there have been many reasons that were given by Department of Homeland Security in terms of why they ended DACA, but only the initial reasons that they gave are the ones that matter. Apart from that, it becomes this post hoc rationalization, any other reasons that they've given since that time. And the post hoc rationalization, these ideas that came, or reasons for rescission that came afterward, comes actually from the Citizens to Preserve Overton Park case, which is near and dear to my heart as a Memphis resident, because that case was the one that prevented the beautiful Overton Park from being turned into a highway. So it was the decision that they used. And so we look at Department of Homeland Security and their rationale back originally during the rescission. And the reason that they rescinded it was basically because of the benefits. So they believe that these additional benefits that DACA recipients obtain, such as the work authorization, is illegal. But they forgot the fact that they can make a decision, and it is a separate concept regarding the law enforcement decision of whether to defer removal actions for DACA recipients. So they didn't really they didn't issue any statement about this deferral of removal concept, which falls flatly within their jurisdiction. They only talked about the illegality of benefits that are provided to DACA recipients. Okay, so that's really the issue. And so basically they're using this rationale that applies to only part of the policy as being sufficient to rescind the entire policy. Okay, so that's really the big issue and the big takeaways there. I will say that this is a procedurally based decision. That's very, very important to understand. And so there was one quote from the court later on that stands out and really helps summarize this. The Chief Justice said, "We do not decide whether DACA or its rescission are sound policies. The wisdom of those decisions is none of our concern. We only address whether the agency complied with the procedural requirement that it provide a reasoned explanation for its action. Here, the agency failed to consider the conspicuous issues of whether to retain forbearance, right? That deferral of removal or deferral of deportation, and what, if anything, to do about the hardship that this would cause to DACA recipients." So, what is kind of unclear at this point, is where we go from here. So, this leaves the door open that DACA renewals and initial DACA applications, maybe even advanced parole, can start being received by USCIS again. But because it's a procedurally based decision, it is also possible that the Trump administration will try to rescind DACA again. Indeed, there was a tweet from just today, that President Trump said, "We will be submitting enhanced papers shortly in order to properly fulfill the Supreme Court's ruling and request of yesterday." So in other words, we will see what happens. I will say we will keep you up to date. You can continue to monitor on our website, www.visalaw.com, as well as our Siskind Susser Facebook page, where there's going to be a link in our resources slide that comes after this. My colleague Lily Axelrod has particularly been very active in, she did a Facebook Live on this as well. And so just let's look for further information on this. The other thing, unrelated type of, I'll try to keep these brief, my goodness, so much to cover. Another memo that, memo that came out 2 days ago on June 17th is basically the USCIS's response to a very historic decision and settlement that occurred with the IT Serve Alliance case versus USCIS. That was basically fighting the government over its very restrictive policies against staffing companies and third-party placement arrangements, which are something that you see more often even in the healthcare setting. There's a lot of hospitalists and other types of staffing companies, nurse staffing companies. So this is a very relevant type of decision. So let's get a little bit to the substance here. So basically, they rescinded two memos, one from 2010 and one from 2018, especially the 2018 one, released during the Trump administration, had very restrictive requirements related to itineraries and related to wanting to obtain end user contracts for staffing companies. So the staffing companies have their clients, they place their hospitalists there, and USCIS basically wanted to see all the contractual arrangements between the staffing company and its end user client, the hospital. In that example, it also definitely had had an IT focus, probably primarily because there's so many IT staffing companies as well. But this was a very restrictive policy, particularly since some of these contracts, they're very confidential, and there wasn't necessarily an agreement on the part of the end user client to even provide that type of documentation or disclose that type of documentation. So there were a series, they did it in sort of a question and answer format, which I thought was very interesting. And so I'll just try to paraphrase some of the important aspects of this. So one of the questions was, should an officer consider an H-1B petitioner and an H-1B beneficiary to have an employer-employee relationship if they meet only one of the hire, pay, fire, supervise, or otherwise control the work of, the employee factors that are listed in federal regulation? And the answer is yes. You only need to prove one of those aspects. And I think the government, for many of these cases, they were trying to get the employer to establish hire, fire, supervise, control the work of. So there was a lot of, they were putting them to this additional burden of proof and additional evidence for the employers that is not required, strictly speaking, is not required under the regulations. There was another question here about, must the H-1B employer establish that employment exists at the time of filing? Yes, bona fide job offer has to exist at the time of filing. Let's see, here, this was a good one. Should an officer request the chain of contracts or legal agreements between the H-1B petitioner and third parties, including the ultimate end client and any intermediary vendors, to assess employer-employee relationship and specialty occupation work? And the answer to that is no. They should not be requiring that these contracts all have to be provided in order to approve. So that's a really big win. That's a very, very big win. And there's some other elements here too that I want to mention. Should an officer require evidence of day-to-day assignments to establish availability of specialty occupation work? Also, no. So in the 2018 memo, if memory serves, they were basically saying, we can't see that there is a specialty occupation work that is available over the entire length of maybe that 3-year request for H-1B status, unless we see these day-to-day assignments of work. Just a very burdensome standard of a lot of documentation, a lot of paper that has to be filed for that. And so it is not the case that there has to be evidence for every day that that H-1B worker is going to be working for the company and working with an end user client. So that's another big victory. Let's see. So there's also the question of well, I will say the other thing about the day-to-day assignment side, they did have a question related to benching, which is another concern. I mean, that's where an H-1B employer is, basically doesn't have a work available for the H-1B beneficiary and is putting them to the sidelines, for an extended period of time. And that is still a rule, but I think that there is room for benching cannot happen by Department of Labor regulations. And also you don't have to show every single day that an H-1B employee has specialty occupation work available. There's a way to strike that balance. And I think that this memo kind of gets at that fact. The other thing is that there was a question about, should an officer continue to apply the itinerary requirement? So that is a regulatory requirement too, but it hasn't been used just for practicality purposes, hasn't been required. And USCIS says that they will abstain from the application of this most common itinerary requirement, unless it is an agent who is the H-1B petitioner. So this is just it's an excellent result, a very happy decision. And I think it will maybe make these third-party placements and staffing company scenarios just easier in the future, hopefully. And I think that there can also be, in terms of the itinerary, there may be some follow-up guidance from the government. They alluded to that, where they may have some other language that they would want to see, but that's unclear as of right now. So there was also a stakeholder meeting from June 18th, so that was just yesterday, regarding resuming in-person services. So this really applies to everybody who has a biometrics appointment at a local field office or has an interview at a field office or naturalization interviews. And so June 4th was really the beginning of the reopening of certain domestic offices, certain field offices. And they just have some of the takeaways here regarding the guide, or basically how this is going to roll out with the reopening. So they say that visitors cannot enter the facility more than 15 minutes before their appointment. There's going to be hand sanitizer at entry points. Members of the public over the age of 2 must wear facial coverings, right, to their field offices, interviews, as well as biometrics appointments. Now, they may have to lift that mask to confirm identity, to take their pictures for biometrics, but mostly will need to be wearing that and will be able to wear those masks. They can only be accompanied by an attorney, or by immediate family listed as dependents, or parents of minors, for example. You have to bring your own pens to these field offices. There will be some screening questions, just to make sure that you don't have any COVID-19 symptoms, for example. They will reduce the number of interviews per day to allow for cleaning. And the interviews, it's interesting, their interviews may be conducted. I mean, one of my colleagues had it all done in the same office with sort of like a barrier between the officer and the attorney, but they've also alluded to having interviews where it's on video, where the officers in one room and the applicants in another room of the field office. So that's another interesting possibility. The ASC appointments, the biometrics appointments, they are basically, there's going to be a phased reopening starting on July 13th, and there'll be an automatic rescheduling of those ASC appointments that were canceled previously. So let's see. The other thing here, we have ICE releases a broadcast message. This was actually from June 8th, and it regards student cap-gap extensions. So basically, you all may be aware of how the H-1B cap subject lottery process has changed, right? There is that initial electronic registration that happened, the pre-registration, that was rolled out for the first time this year, this cap filing season. And you file this registration, bare bones registration, $10 filing fee. And the lottery is run, and then there is the results come out, and the individuals who were selected in the lottery receive a receipt, a pre-registration selection notice. It's not really a receipt, it's a selection notice. And they use that selection notice to file the H-1B, okay? Once they file that H-1B and they receive an H-1B receipt, that is when F1 cap gap extensions can happen, right? That is that ability to bridge the gap. The cap gap is the ability to bridge the gap between the graduation of the student and the end of their OPT, for example, and the start of the H-1B employment, which would be October 1st. So you have somebody graduating in June, or their OPT ends in June, for example. They file an H-1B, and they are, prior to the expiration of their OPT, they're able to get that cap gap until October 1st. So this process really isn't changed necessarily if you just understand that pre-registration is a concept completely different from the filing of the H-1B petition. You have your pre-registration, you get your selection notice, you file your H-1B, your H-1B is received, right? That filing of the H-1B petition itself, substantive petition, prior to the end of the OPT, allows for the cap gap. And that's basically what this SEVP broadcast message was saying. Only after the employer files the petition can the F1 student, avail themselves of the cap gap extension. The other thing is that SEVIS was modified on May 22nd to automatically add a cap gap extension to the records of eligible F1 students whose H-1B petition was received by USCIS. So this is now an automatic process, which it was not previously. The last thing I will note to you all, this is, there's definitely no finalized rulemaking or anything of that sort, or even proposed rulemaking regarding OPT and H-1Bs. There's definitely been in the regulatory proposals of DHS, sort of their wish list, a lot of changes that have been contemplated for OPT and H-1B, but nothing finalized. We will see sometime there's supposed to be a spring wish list that comes out from DHS, but we don't have that yet, and we're into the summer. So we will see. That should be coming out, and we will know more about whether there could be any rulemaking that comes out for OPT. What some of the rumblings and things that we had heard would be a restriction or rescission of, or intention to rescind the 24-month STEM OPT extension, which came out in 2016. And before that, there was the 17-month STEM extension. This would be to do away with all of this, all of the STEM, and then also to limit standard post-completion, the 12-month OPT, to only those who are in the top of their class. So again, these are just possible proposals and things that we have been hearing, and nothing that has been finalized. There's also been just some, just generally, there's been some desires to in the H-1B context, to revise the definition of specialty occupation, which is really the most common reason you get a request for evidence nowadays, is because of specialty occupation. So they want to revise that definition and make H-1Bs harder substantively. And then to also redefine employer-employee relationship, which maybe is going to be something more on their radar, given the IT sort of alliance settlement and the IT memo that I addressed earlier. They may want to try to act on employer-employee relationship. Remember, the election's coming soon, and so we'll see how far things go. But these have been your academic and healthcare immigration updates for June 19th. I'm just going to show you briefly, well, there's I had wanted to show you all our resources page as well. Let me see if I can get to that actually here. If I share this with you all. Okay, let's see. So I'll just show you the resources here. These are some, basically some, you can find our Facebook page. You can see the DACA decision as well, and the IT serve memo too. And we will just continue to put out more updates, but we thank you all very much for tuning in.